Thank you, Rachit. I really am privileged to be here in your platform, and I convey my gratitude for inviting me to hear something about this law and particularly the recent judgment from the Honorable Supreme Court. And my heartiest gratitude to also Samita Sarma, who's the marketing head of Taxmann, and including the Taxmann and all its dignitaries. And I thank you all the audience of yours who are sparing their time to be to hear me out on this particular extremely important and volatile subject. To begin with, as you said, the subject, particularly the money laundering law and the recent judgment. I want to give a brief idea about what exactly the money laundering law means to me. The law that is there before us is actually, according to me, it transcends time and territory. And it is at a time where we are actually trying to govern even the people's morality. And I always say that this is a law which actually governs the entire population of the world of today, tomorrow, and yesterday. And it has no boundary on limitations, barring, of course, to a certain degree, where the Honorable Supreme Court has explained on the aspect of applicability of the money laundering law to the extent of amendment to the schedule. That's one part. The second part, let me tell you, this is now it will become the era of reasons to believe. And before I go into it, I just want to give you a broad overview of this particular legislation. And perhaps I think, let me summarize that what is this law is all about. This is a law which, of course, this particular recent judgment of the Vijay Madanlal Choudhary tried to explain to the extent saying, contrary to the perception of even including the lawyers, that this is not a pure penal law. This is also not a pure regulatory law. This is actually a mix of these two, and it is a very unique, sui generis, unique law. And precisely for this reason, the entire dimension of the reasoning put it to the court on the angle of the criminality, but ended up in the form of a judgment saying that this is not confined to the penal law. It is actually covering also the regulatory component of the law, because it tries to prevent the money laundering as an offense. Now, to summarize what this offense is all about, and particularly the overview, this is a law which is enacted by the Parliament on political declaration adopted by the United Nations General Assembly in the year 1990, and called upon by the United Nations General Assembly in 1998, to which all its member countries to legislate a law, that is prevention of the money laundering law. The genesis, it starts with the drug law and terrorism law, but particularly began with the drug law in America in 1910 and on. In the Latin America, as you all know, the drug peddlers, they used to launder the money. That's how the concept of the laundering came in. But I don't want to go into that aspect. I wanted to only give you the dimension because that is also an important criteria of discussion in the Supreme Court. The laundering as a concept emanated with the drug peddlers 1912 to 1920, ending up with the legislation as far as India is concerned in 2002, with the international commitment as a global commitment of all the countries. It was actually gained currency as a legislation post the 9/11/2001. That is the time where the Twin Tower is attacked and America was at its threshold, security reasons. In a way, I would call it as a foisted the world over. And that is how how the terrorism actually has shrouded and has gone into the different aspects of our life. And that is how the political declaration is trying to really capture that. But that was actually the reasoning, immediate reasoning of this particular legislation as far as India is concerned, 2002. Original genesis is the drug law, drug menace. Now the terrorism is the immediate reason, and that is how the 2002 law came in. Now, what's this law is all about? as far as the design of the law, Indian architecture is concerned, there are two dimensions to it. One is the penal law, which is called the money laundering as a penal consequence, as a penal law. And there is also a prevention of money laundering, where the confiscation of the proceeds of the crime, that is the property derived, obtained from the criminality of money laundering, criminality of the scheduled offense. So that is how the proceeds of the crime and the offense of the money laundering, that particular proceeds of the crime is getting laundered, used, acquired, possessed, projected, claimed to be an untainted property. That is how is called the money laundering. The money laundering law is being attempted to be addressed. This particular offense of money laundering is attempted to be addressed by a design of the law where a criminal element and the criminal element is there, one division. I think this is called the scheme of the PMLA, where there is a prosecution penal action is a one component and the adjudication of civil action is another component. Broadly, that is the twin tower as far as this particular law is concerned, and the aspect of the penal consequence and aspect of the civil consequence. And how do you decipher this particular penal and civil consequences? One component of the action of accounting, prosecuting the offender of a money laundering is through a process of the prosecution, which is through the process of a civil court adjudication. That's a one part. Second component of this particular law is called the adjudication. Adjudication of the properties, which is derived or obtained from the laundering of the money laundering, which is through the scheduled offense, which is called the criminal offense. I'll just explain a little bit about it. So these are the two limbs of this design of the law, a component of a criminality of prosecution and a component of the adjudication of the proceeds of the crime are addressed through a two different and unique set of process. And both of these processes are navigated and investigated and acted, inquired by called authorities. Broadly, they are the Directorate of Enforcement authorities are assigned responsibility as under this particular statute as the authorities. So one is the independent authorities, which is actually will investigate the offense. There are two other different limb, prosecution and adjudication, and that is how one is the penal action and one is the civil action. That is what the Honorable Supreme Court, in its particular last judgment, Vijay Madanlal Choudhary, July 2022 judgment, has explained, while thwarting all the constitutional challenge before it by saying that your entire line of argument to challenge the constitutionality entire provisions, about 15 odd provisions of this particular statute, are actually concentrated on the line of the penal jurisprudence, whereas the component of the civil action is also an important limb of this particular design. And the objective of this particular statute is not only confined to prevention of the money laundering, it is also for a prosecution of confiscation of the proceeds of the crime generated or obtained from the criminality that is a scheduled offense. So that is how the entire design of the statute is there. But let me tell you, the money laundering has no timeline, has no limitation, except to the extent of the reasons to believe. This reasons to believe is something which the authorities are empowered to record before initiating either of the prosecutions. That's very interesting aspect. And that also makes this law unique in many ways. And particularly it has, according to my understanding, the entire criminal jurisprudence is inverted. And how the Honorable Supreme Court has analyzed that particular challenge is, in fact, I would say that those challenges were thwarted on solitary reliance of some of the judgments, which is rendered at different point in time on different concepts. But money laundering law, ironically, is a combination of all jurisprudential inversion of principles. It's a one such law which inverts the presumption of innocence. It inverts the burden of proof. It takes away the power of the court to grant you bail unless it certifies that you are not guilty of money laundering. And those are the very, which otherwise is called, criticized by different people, including the legal luminaries, are extremely draconian. But according to my understanding of law, which I believe is certainly, it is not law at all. How, I will explain a little later. Now here, the concept of money laundering begins with a possibility of and particularly that inversion of the concepts, the jurisprudential concepts, which transcends time and territory. As I told you, that the proceeds of the crime obtained from that of the scheduled crime, it is like this. You are accused of offense, which is called as a predicate offense or a scheduled offense. And in that scheduled offense, if you are generating or obtaining any proceeds, property, tangible, intangible in any form, that is called the proceeds of the crime. Those as a proceeds of the crime will be prosecuted through the process of confiscation, while the offense of money laundering will be processed through a special court. Now, the devious elements of this particular law is this. It has given absolute jurisdiction to the ED, where the ED will have to make a only declaration in the form of a writing that I have reasons to believe. Many of my colleagues will connect with this concept of the proceeds, reasons to believe. Like, for example, Section 148 of the Income Tax Act. There are also many other legislations where this concept of the beginning a prosecution, which is broadly regulatory, not a criminal prosecution per se, they're related to regulatory. If you will map the entire reasons to believe, link the prosecution in various branches of the law, you will see that those are broadly the regulatory law, like income tax law, where your documents are already there, like customs, like different legislations where the taxing provisions are there, where the authorities have already collected records from you, and they are evaluating those records. And on the basis of that records, they will initiate an inquiry. Whereas this is the first time, I repeat, please note, very important. This is a legislation which is a combination of the inversion of the entire criminal jurisprudence, A. B, it is also a legislation whose virus was justified, constitutional validity was justified on the ground by saying that these are not a pure criminal law. This is also a regulatory law, and therefore the jurisprudence developed through the judgments are applicable in this case to uphold reasons to believe doctrine A. B, inversion of the criminal jurisprudence of innocence of presumption, burden of proof, or for that matter, the bail principles, twin conditions, etc. Only on the ground of the doctrine called the legitimate state interest, compelling state interest. This is a doctrine developed where the Article 21 was not entirely, and particularly the protection of taking a preventive arrest, etc. In that kind of legislations, those legislations were upheld on the ground of states' compelling interest. And this particular doctrine also in a way invoked to the extent saying that this particular legislation, even if it has inverted many concepts of criminal jurisprudence, which is borrowed from that of the CRPC, is not applicable in this case. And in the instances of other cases and judgments, those principles have been upheld by the Supreme Court, and therefore This also legislation found muster as far as the Honorable Supreme Court is concerned in the recent judgment. Whereas if you combine all those jurisprudential principles about 5 and 7, for example, burden of proof is inverted in this case, that the authorities, the moment they will form opinion and will put it in writing, from the material, we don't know what is the content of the material. And to that extent, I would like you to go through the content of the suspicious, the definition of the suspicious transactions for a moment. If there is a slide already there, just have a look at it. It's very important. This suspicious transaction, that is day-to-day transactions of yours, which you do not give it to anybody, which you may be having it. Next slide, I think. Next slide, yeah. This is the Rule 2, 1G, a definition of the suspicious transactions and maintenance of the records rules, where the reporting entities, such as your banks, financial institutions, and other intermediaries where you operate, including many other regulators under different statutes like SEBI and other. So reporting entities here, look at the definition of the suspicious transactions, and I'll tell you the devious element of this particular transaction vis-a-vis keeping in view the reasons to believe as a phrase that the administrator, the authorities will invoke against it to trigger this particular law, means a transaction which to a person acting in good faith gives rise to a reasonable ground of suspicion that it involves proceeds of crime. Now, tell me, a ED, or for that matter, a banking company or a financial institutions, while acting in good faith will give rise a transaction when he sees it. That means your transaction between two parties will be seen by a third party, and he will, if suppose that particular transaction will give rise to a reasonable ground of suspicion that it involves proceeds of crime, or it gives rise to a reasonable grounds of suspicion that it may involve the financial terrorism, this triggers under this particular law rule, those intermediaries will be forced to give those information and share with the Directorate of Enforcement in the authorities under the PMLA. Now, those will be the material before the authorities, and then they will form their opinion as to whether you are involved in any proceeds of crime, whether you are involved in the money laundering. Because remember, proceeds of the crime is a one aspect. Money laundering, these proceeds of the crime, using these proceeds of crime, directly or indirectly. Acquisition of the proceeds of crime, directly or indirectly. Possession of the proceeds of crime, directly or indirectly. I would like you to go through the definition of the proceeds of crime, which is very, very critical, that this is also is the action which is under regulation. So proceeds of the crime, if you see the definition, and in this case, proceeds of the crime is just see this proceeds of the crime as a definition. That any property, remember, proceeds of the crime is actually the property or the value derived or obtained directly or indirectly as a result of a criminal activity relating to the scheduled offense. For example, scheduled offense is 420, cheating, fraud. A alleges B that you have defrauded me, and thereby some of the money is aligned with a B. Now, because this fraud is a scheduled offense, predicate offense, the proceeds, the property, the value derived or obtained as a result of the criminal activity relating to scheduled offense of 420, that will be treated as a proceeds of the crime. Or if it is a physical property, then that property. Or if it is a value of the property, that property. Or a property that you bought out of the value of that property. or in exchange of that property. So anything, any traces of any property or value which is obtained or derived as a result of the criminal activity is called the proceeds of the crime. And that is the definition section which provides the proceeds of the crime. And in the explanation, which is more important, that in the explanation it says that this proceeds of the crime also includes the property used in commission of the offense of scheduled offense. Means, suppose a vehicle is used for a commission of an offense, a scheduled offense, then that vehicle also is a property, because if that is a property involved in the commission of offense or used in the commission of offense, that is also proceeds of crime. But yes, the Honorable Supreme Court has read down this provision by saying that the explanations to definition of the proceeds of the crime cannot exceed the proceeds of the crime definition, which says that any property obtained or derived or involved as a result of the criminal activity is the proceeds of the crime. So this is one component. Now, importantly, if you see the section 3, before I go to the suspicious transaction, I want you to read for a moment this section 3, which is very, very important. And it is extremely important in the context of understanding that this particular law theoretically covers the entire 8 billion population. It's just for the benevolence of the director to declare whether he has a reasons to believe that somebody is involved in the money laundering offense or is involved in the proceeds of crime. This is the only statement he has to make in order to trigger the entire process of criminal civil action against you. And what this section 3 starts with, it says that whoever directly or indirectly, remember, a criminal offense, when we talk about directly or indirectly also, its reach is extremely far-reaching. So whoever directly and indirectly attempts to indulge, very important, or knowingly assists, knowingly party, or actually involved. So in all the 4 alternatives, whoever directly, indirectly attempts to indulge, knowingly assist, knowingly a party, or actually involved in any activity or process. Actually, money laundering is with respect to this activity and process. That is also our Honorable Supreme Court has explained. So in any activity or process relating to the proceeds of crime, as you have understood the proceeds of crime, what it is, that is the property or value of the property, which is obtained or derived in relation to the offense of scheduled offense, and that property is the proceeds of crime. Now, any activity or process connected with the proceeds of the crime, including its important is very much here, that it also says activity, process relating to the proceeds of crime. So whatever you do, any process or activity relating to the proceeds of the crime, including its use. Now, for example, a lakh of rupees is involved in the allegation of cheating, which is a scheduled offense, and a scheduled offense is registered or contemplated. The Directorate of Enforcement can begin the exercise of adjudication process, because it can begin the attachment procedure, provisional attachment, which is without also registration of an FIR under the scheduled offense. That's very critical. Now, what happens is that a scheduled offense, proceeds of the crime, out of that, this is prosecutable under the scheduled offense by local police. Then this proceeds of the crime and activity of laundering, these two also will be prosecuted by the ED. This here, just if you can understand, this is the scheduled offense. Any money, any value, any property derived out of this scheduled offense, directly or indirectly, and that proceeds is also prosecutable. That is second. So scheduled offense prosecution by the local police is, or CBI, is the first prosecution. Then there is a second, proceeds of the crime. The proceeds of the crime generated out of it, that will also prosecutable by the ED. So provisional attachment, seizure, confiscation, possession, vesting, that is a procedure prescribed under the PMLA. That's the second line of civil prosecution can happen out of the same action. Then there is a third prosecution, which is called, if this property, proceeds of the crime, is getting laundered. What do you mean by the laundered? Any activity or any process with relation to the proceeds of the crime, which is including its use. If you use these proceeds of the crime, if you conceal these proceeds of the crime, if you acquire these proceeds of the crime, if you possess it, conceal it, or you project it as an untainted property or claim it as an untainted property. So this activity of yours is called the money laundering. So therefore, one action, three prosecution. One action of fraud, three prosecution. One is the local police or the CBI for seizure offense, which will be happening in the normal court. Then there will be a proceeds of the crime, which is generated or obtained out of it, which will be prosecuted by the ED through the process of attachment, confiscation, possession, vesting in the central government. Unencumbered, whatever the encumbrances are there, all without. So the entire proceeds of the crime, the central government will be the owner, but then he will be prosecuted. The third consequences is ED will prosecute under Section 3 of the Money Laundering Act, which is the definition of the Money Laundering Act. That means not only the possession itself will be one, it will be used if you are using it, if you are concealing it, if you are acquiring it. Now, let me tell you, with the burden of proof shifted on you, only on the recording of the reasons to believe by the ED to prosecute two additional prosecution. One is civil prosecution, one is a criminal prosecution before the special court. With the burden of proof shifted against you, with ECIR, the allegations being in all, again, is in a concealed cover, chances of you dislodging the offense of money laundering, which says directly, indirectly, attempt to indulge. These are extremely important and critical phrases. Not indulge, attempt to indulge. Then you use it, you claim it, sometimes, and mens rea, a guilty mind, I think, is not there in the part of the Section 3 definition. If you see it carefully, the mens rea, that knowingly you are using it, knowingly you are concealing it, knowingly you are in possession of it, knowingly you are acquiring it, it's not there. If I, as a lawyer, get a fee of, say, 10 lakh rupees from my client for filing an SLP, if that is treated as a proceeds of the crime with a quote-unquote reasons to believe made by the director, and the prosecutions are happening there, then I will be prosecuted equally. And the fact that I'm in possession, the fact that I'm in using, the fact that I'm in concealing it, I may not be concealing it, but the fact I'm using it, I'm in possession because that money is lying in my account, that wire has hit my account. So obviously my money is lying in my account. Whether I'm claiming it knowingly or unknowingly, whether I'm projecting it knowingly or unknowingly, suppose if I don't know that's a proceeds of crime, obviously I'll claim it is not a proceeds of crime. But my claim will not be believed by the ED, and then I'm bound to be convicted. So what is when the onus is shifted against me, burden of proof is shifted against me, contrary to the known jurisprudential principle that presumption of innocence is automatic, whereas the statutory policy of this particular law says that I am guilty, day one. What nature of material I can bring in to dislodge and dispel that apprehension, because these are all apprehensions. What material, basing on which this particular observation will be made by the ED officials, while initiating both the prosecution of attachment as well as criminal prosecution of money laundering. What material they may see it, except it is an estimation. After all, they will be forming opinion on the basis of the records. After all, it may also make opinion on the basis of some evidences, oral evidences of somebody, which they will be extricating through the section 50 by threatening the witness at that stage or the accused at that stage, which is not an accused, inquiry stage, section 50, another a very, very dangerous provision of law, where it says that a person can be invited, inquiry proceeding. Obviously, they would not know whether the person is that time is not the accused stage. So it is only invited as a persons to inquire as to what is this proceeds of the crime, what is this. It's, if you see it in the totality, section 3, section 24, section 22 and 23, and then section 50, where the inquiry proceeding is initiated by the director. It's like a roving inquiry. The ED has to form some kind of opinion. He may have your balance sheet profit and loss account. He may have obtained some kind of a banking transactions, which they, as a matter of policy, direct the banks and financial institutions to forward those informations to them. They will just analyze that. Can I ask these questions for a moment to think with the definition of section 3? Is the currency, which we call it as a proceeds of crime, if at all, or the property, which you call it as a proceeds of crime, do they have any name on it? Absolutely no. As far as the offense, scheduled offense is concerned, which you claim that the proceeds, the property, the value derived, obtained from that criminal action. So there are two angles. This legislation was made with the background of the international community commitment, which I began by saying it's a drug peddling, organized crime, terrorism was the focus of the world over countries to tackle. Now today, by inducting schedules after, the act statutes after statutes under the PMLA, which is currently standing about 30 odd statutes are annexed as a scheduled offense. There you will find Companies Act, you will find Copyright Act, you will find Environment Protection Act, Care Act, you will find a lot of, your IPC, whole host of legislations. Some of them, even I think copyright and trademark, some of them has no linkages to this organized crime. Broadly, why the TADA, this kind of a legislation or a UAPA, legislations were enacted on the ground of the compelling state interest. We are actually inverting the presumption of innocence against the accused, so that when the prosecution begins a prosecution, with whatever reasonable material they may have, it is for the accused to prove his innocence. And those all host of body of laws were enacted, keeping in view the gravity of the gravity of the offense thereunder. Now, we are applying those jurisprudential principles to uphold this legislation, not realizing that the entire host of trigger, the second prosecution, third, as I told you, the scheduled offense is the first prosecution, proceeds of the crime is the second prosecution, and the criminal prosecution is the section 3 money laundering of prosecution. So there are 3 prosecutions out of 1. And there will be 2 agencies. Of course, the moment the section 3 comes up, of course, the money laundering offense also goes to the a special court. That's a different matter. But you will be faced with 3 consequences from out of the same transaction. What was the objective of this particular statute well enacted? to capture the organized crime. So when we do that, this legislation was enacted with that objective in mind. Today, the cheating case, all trivial case, and then it can only be done by the ED only. The cognizance can be taken by the special court with respect to the money laundering only by the special court on the complaint made by the authorized officer by the central government. So, definition of money laundering, inversion of the innocence, presumption of innocence, burden of proof. The entire edifice of the Evidence Act is turned upside down with this principle. And what is the foundation? For example, I have bought a property. Like any other, as you know, the Prevention of Corruption Act, an officer amassing property beyond his source of income. Obviously, the entire source of income is from government sources. And therefore, there is a legitimate law made to capture, to prevent the corruption. That's an objective here. But what about an ordinary citizen? The offense doesn't distinguish as to whether it is only where the Prevention of Corruption Act as a scheduled offense. It is also applicable to under 420, 450, cheating and fraud. Now, what state has any role to do with that of an offense of 420 by a person who has no linkages and relationship with that of the state instrumentalities and resources? Now, therefore, what I am intrigued by the fact that the legislation with an objective commitment to the international world with a menace of money laundering, organized crime, terrorism, is a stretch to go into the arena of pure law and order issue way, which is covered under the IPC and different special statutes, where the state has exclusive jurisdiction as far as the federal structure of Indian polity is concerned. But stretching this law purely on the claim, I have reasons to believe, and then to say that there is an adequate safeguard mechanisms. In other words, as the definition of Section 3 says, with no mens rea, barring in few instances, no mens rea is there as a precondition, what you tend to get is complete conviction. And with every transaction, ED within its jurisdiction can switch from A to B transaction to C transaction. Each transaction can become a potential proceeds of crime. Now, each transaction, if it is seen as a potential proceeds of crime, you deal with one transaction, you go to the second transaction, you go to the third transaction, there is no end to it. With no limitation, you are always under the thumbnail of the ED perennially. Theoretically, it is a law, aside the political rhetoric, and let me tell you, I have personally, I believe, maybe this is a legislation which is good in a sense that it can account the politicians, the executive. If they wanted a law for the entire India, let them be prosecuted thereunder. After all, their entire edifice of their earning, their entire edifice of their living is actually linked to public resources. At best, one may say that somebody's ill-gotten money is using it, in possession of it, owning it, let that be prosecution. No problem. But for that, there are different legislations already operating, even under the Prevention of Corruption Act. All public officials, the public officers, those who are dealing with the public functionalities, they're all their money can be taken back if it is disproportionate to their earning. And there are legislations which tackle this problem. But if you see this particular offense, this is also getting now used against the corporates. This is also being used against across. It's a different matter. Today, the ED doesn't have the entire infrastructure at its control and command. Otherwise, as I told you, the entire 8 billion population is under its thumbnail. If it starts inquiring about anybody and everybody, it can do it under Section 50 to bring about some material to be able to trigger the Section 5 provisional attachment, to trigger also the prosecution under Section 3, because the presumption in any proceedings, because Section 24 says that he's an offender also of when there is a prosecution under Section 3 of the offense of money laundering, there is a presumption that he is involved in the proceeds of crime, and then the trigger of provisional attachment, the entire property gets attached. Your bank money bank account is sealed, your entire property gets attached. Because the government wants to take away, because they believe that this is a proceeds of crime. So, with all those amendments subsequently being carried out, and with the explanations given by the Supreme Court in the very recent judgment of the Vijay Madanlal Choudhary, the effective outcome has come in this manner, that the Supreme Court has stated that there are adequate safeguards. What are those safeguards? The safeguards are, I think there is a list of safeguards which the Honorable Supreme Court has stated. One, just because the director, the officer, which is a public servant, forms an opinion, this is a safeguard number one. Number two, it forms that opinion based on the material in his possession, safeguard number two. The moment he takes action on the basis of this, whether it is search, seizure, whether it is attachment, provisional attachment, etc., he informs, he gives these informations, this copy of the reasons and the materials to the adjudicating authority. That is also a safeguard. Then the adjudicating authority on receipt of that will give you a so cause notice and ask for a reply, etc. That is also safeguard. You get an opportunity, you get. That is also a safeguard. Now, suppose if you do not agree with that, you can also challenge it in the appellate tribunal. That is also a safeguard. If you don't succeed there and they go to the High Court, that is also a safeguard. So the nature of the safeguard is, to my mind, is certainly, because in any case, the entire trigger is on the basis of a transaction or a record which the director or the enforcement authorities can lay hand off during any process, and that can be the basis for taking the second and third consequences under the statutes. And that is where the danger lies, that what is that material? And as I was telling you, that a concept called the reasonable suspicion, the suspicious transaction, defined under 21G, Rule 21G of the your money laundering rule, a person acting in good faith, if it gives rise to a reasonable ground of suspicion that it involves a proceeds of crime. Now, what is these grounds of suspicion? What is the barometer? Any transactions can be seen to be suspicious. What is reasonable to me may not be reasonable to you. Again, it is a purely subjective. What is the barometer of a reasonability? Similarly, if that person acting in good faith, seeing that particular transaction, if it appears to him that this transaction is made in circumstances unusual and unjustified complexity, what is their barometer? So that means if I am running today a Honda City and tomorrow I am buying a Fortuner, that can be also giving rise to some kind of a suspicion. Similarly, if it appears to him that it has no economical and rational and bona fide purpose. Now, test this. the universe of trigger under this particular legislation of the attachment proceeding against your property, proceeds of the crime, and the universe of the ground which triggers your money laundering prosecution under this law is interestingly starts with the suspicion. And whatever the material, which we say that a material which is going to a reasonable man, a person acting in good faith will form this opinion. Now tell me. So these are a jurisprudential principle which has come in one legislation, only one legislation, which has nothing to do with that of any regulation per se. Because the doctrine of reasons to believe as a prosecution parameter for the regulator to trigger any prosecution against you was upheld in those cases, in those law which has elements of regulation. For example, Customs Act. For example, because where you are acting under that. You are also taking recourse to the regulatory mechanisms thereunder. But here there is none. So, in the sense that this particular legislation getting triggered with a suspicion transaction getting reported by the intermediaries, with the definition of money laundering so wide, so vague, shifting the burden of proof to you, treating you guilty, presumed guilty on day one. And importantly, the entire trigger starts with a reasons to believe. To my mind, there is no jurisprudential policy or principles till date existing which can justify this legislation in its entirety. As I have told you about this legislation principles and the concepts, now let us go to the broad points of the judgments. If you see this particular law in another dimension, it is like this, that every transaction is a potential proceeds of crime. That becomes the proceeds of the crime only on the certificate reasons to believe given by the authorities. Even though the Honorable Supreme Court in this particular judgment has stated that this cannot be triggered on assumption, the catch lies this. This judgment is not giving clarity on the aspect of the presumption, whether without the material or presumption lying on the material. Important. This judgment is upholding about 15 virus challenge of 15 different provisions, running from bail aspects and the bail. And interestingly, this particular judgment has differed with the observation of Nikesh Tarachand Shah judgment of 2017, equal bench of 3 judge of the Honorable Supreme Court, to the extent saying that there is a compelling state interest to have twin conditions of bail, where I stated to you that as far as the section 45, for a moment, I want you to go through the section 45 to understand, to complete the dot that why this is a complete inversion of the jurisprudential principle. This section 45, interestingly, if you can have a look at it in a briefest possible way, which I think my colleagues have prepared in a skeletal form for you to not to read too many words, but in the briefest possible way. The section 45, it says that if a section 3 accusation is made against you and you are presumed to be guilty of offense of money laundering, and if a bail application is filed before the special court, that particular law of bail of the CRPC is not applicable at all here. They will be applicable in addition to section 45. And what section 45 says? That no bail will be granted. It starts with this. No bail will be granted. Notwithstanding the criminal procedure court, no bail will be granted to you. If the public prosecutor, again, is an executive appointed authority, a public prosecutor has to be given the opportunity to oppose the bail. That's a first condition. That's why we call it as a twin condition of section 45. That public prosecutor has to be given an opportunity before granting bail. So earlier, the court could have granted the bail, seeing the material in entirety, because that, after all, hit the Article 21, right to life and liberty, without even giving notice to opposite parties, sometimes in extraordinary situation. But now it says that the public prosecutor has to be given the opportunity to oppose the bail, number one. And number two is very important. Here says that if the public prosecutor says, no, don't grant the bail, that means you are in the hand of the public prosecutor. Then the court have no much of the option unless the court is satisfied on the basis of the material, the same material which was the material before the authorities to form opinion that yes, you have committed an offense of money laundering or you are involved in the proceeds of the crime. So the same material will be tested by the court, has to give a positive finding that you are not a guilty. Now tell me, at the threshold stage, as such the section 3 is so wide and vague, where the mens rea is also not there, and the moment that there is a proceeds of the crime and you are using it, that itself is an offense. How on earth, which court will form that certification that you are not a guilty of offense of money laundering? Allegation of money laundering or involvement of the proceeds of the crime whereof you are in possession, the moment is made by the authority and the civil prosecution of attachment starts or the criminal prosecution starts, you see the section 3 where the mens rea is not a criteria. How on earth a court can grant a bail? What will be the threshold? Because if you are really, suppose my client gives me X amount of money, that is a proceeds of crime, I'm using it. Anybody. It's a clear case of conviction. How can that will be a bail also? Forget about bail. Presumption is against you that you have to disprove it. Now prove karte raho. What is the threshold of that proof? Because in any case you are using it. A and B, they are involved. A is the accused in this scheduled offense. B is the sufferer, complainant in the scheduled offense, predicate offense. Now A sends the money that proceeds of the crime generated out of that allegation of the scheduled offense. It comes to me, I'm in possession, I'm in use, I'm an offender. Because it states, whoever directly, indirectly attempts to indulge, to use it, knowingly assist, knowingly party, or actually involved. Now use, including its use. So mere use also is an offense. Unless we use the mens rea, because the phrase including, of course, the amendment of 2019 brought in a kind of a clarification to section 3 by saying that the activity and process of money laundering relates to those actions of use, etc., with a knowledge, with a attempts, knowledge actually involved. In that case, possibly, as of now, there is no clarity on this. Possibly there is some kind of a mens rea we can induct into it. But the section 3 per se, as it exists today, it's quite wide. Now, going back to this judgment, there are 15 sections, 15 provisions whose virus was challenged, was thwarted. And the entire justification for that judgment is, while thwarting it, is that it has concentrated on the purposive interpretation. While drawing that interpretation, rules of interpretation, mind you, this is a criminal law. A. B. Even if a component of attachment is a regulatory law or a civil law, which it is not in a way, to my understanding, but in that sense also, this enlargement of the scope of the statute to the extent of inducting these additional features into it on the ground of the purposive interpretation, and those principles borrowing from TADA, UAP and other legislations, to my mind, is something need a relook. And the line of assistance, according to my humble assessment, with due respect to all, the line of attack should not be the CRPC, just because CRPC says, because the Supreme Court in this judgment has stated that the PMLA is a special law. As long as the legislature, nobody challenged the legislative competence of this particular law, except to the extent of this law amended through money bill under Article 110. That ground of challenge, whichever the amendment were carried out by the money bill 110, Article 110, they are now being referred to a 7-judge constitution bench, because that a question is pending before Roger Matthew case, a 7-judge constitution bench. That is where the court said, to the extent of those challenges on the ground of the money laundering route, money bill route, is now not being answered here. It will be answered there in the Roger Matthew case. So therefore, to the extent of that, that challenge still survives, that ground still survives. As far as the other grounds are concerned, the other grounds which in this case were raised, the one of the grounds, substantial ground, was the criminal jurisprudence, the principles that we all know under the CRPC. Because in this case, the court said that the ED is not a police officer. And therefore, the challenge of the parties to the extent of borrowing the principles of the CRPC and then the Article 23 was thwarted by saying that at the stage of the inquiry, person who is invited to participate in the inquiry, before trigger of the formation of opinion that I have reasons to believe, at that stage the persons invited are not the accused. And therefore, the protection of the Article 23 is not extendable. To my understanding of law, a serious miscarriage is there, because fundamental right under Part 3 is a nomenclature in the Constitution and is a caution to the state not to trample the natural right of the people. According to my understanding of the Constitution, of course, that needs to be tested in the appropriate court, that the fundamental, and this is certainly not out-of-box understanding of law. It is indeed, these traces are there in some judgments and all. Fundamental right as a text, we, the people of India, while adopting the constitution, have, through the part 3 of the constitution, has cautioned the state not to trample our natural rights. And to that extent, if you can only, and that can only be trampled to the extent of the legislation, and if the legislation is reasonable in nature. My right, all my rights, they need not be a charity of the executive. They need not be a charity of legislature. They are all natural to me. Now, if it is to be impinged, it has to be impinged through via law. So irrespective of the life, liberty, freedom, whatever we call it, under whichever the article it is, my all rights are independent. And they're all independent of constitution. Constitution only a text by we the people of India. Drawing the perimeter of governance. Cautioning the state, while you govern it, don't trample it, but you can trample it to the extent of the reasonable restriction only through the legislation. To the extent of the Article 23, I'm drawing that principle here. When a legislative, a constitutional caution is given to the institutions and the state, saying that no person accused of any offense shall be compelled to give an evidence against himself, a threshold at the level of the accused, which is much a higher threshold than the ordinary person. Can the legislature will take the circuitous route and will say that, no, because you are not an accused, therefore the Article 23 is not a caution against me? If an accused also cannot be threatened, coerced, forced to give evidence against himself, self-incrimination doctrine, can this test of caution against the state is not applicable to the legislature, that look here, you cannot legislate a law bypassing 23? You cannot legislate a law to caution to threaten the citizens that come and incriminate against yourselves. So, to the extent of this particular judgment, saying that the Article 23 is not applicable because at the stage of the Section 50 of inquiry proceeding, because all the investigation defined under this particular act, they have enlarged it to cover also the inquiry proceeding and the function of inquiry. Thereby, they have inducted the Section 50 proceeding under the investigation, and thereby completely sidetracked the Section Article 23. This is something, a new ground of challenge is certainly not being put forth nor being addressed. Looking forward to appropriate time to be able to buttress this proposition of law to the extent of provisions of Section 50 threatening to self-incriminate. Invocation of Article 23 against that is something need to be looked at in days to come. One. Number two, here the entire legislation was upheld also on the solitary ground. There is an objective of the statute to prevent money laundering, and this is not only one objective of the statute. This is also an objective to confiscate the proceeds of the crime. So not only it is penal in nature, it is also regulatory in nature. And because it is both, there is an objective of the statute. Some criminals are objective, some prevention of money laundering is also an objective. And while this is the objective of the statute, every provision serves that objective. And this is reasonable according to the assessment of the Honorable Court. Because they are reasonable, why? Because there are adequate safeguards. And the safeguards I have noted it down. Those are the safeguards according to the Honorable Supreme Court. Now, those safeguards, coupled with the fact that there is an objective and a reason and a rational relationship between the objective to be achieved, this entire legislation was upheld. The ground of commitment to the international community and the menace of money laundering, a political declaration at the United Nations stating that it impinges the sovereignty and integrity of the nation, it impinges the financial system, which of course the Nikesh Tarachan judgment to the extent of the twin conditions has given a different view on that, saying that we cannot extend that objective that far. In Nikesh Tarachan, it stated that we cannot extend that objective that far to deny the benefit of the Article 21, right to life. And let me tell you, the challenge of central legislations whose competency, legislative competency is not challenged, challenging that legislation on the solitary ground of the Article 21 is not a very safe, because what Article 21 says, no person shall be deprived of their life and personal liberty except in accordance with the procedure established by law. Now, if the PMLA talks about a law which prescribes a procedure of deprivation of life and liberty, that the very ground of Article 21 goes. Because 21 is invocable only when there is a law. There is no law. And if there is a law, the authorities under that law is violating that law. But even in that event also, violation of the statute also cannot be a ground to challenge the violation of the statute. So Article 21, coupled with the Article 14, which was argued before the court, and to the extent the Honorable Court has come to a conclusion, yes, there is an objective, a noble objective, which is to be achieved. And there is a reasonableness of that provision. And the test of reasonability was justified on the ground that these are the safeguards while balancing the provisions of law. And the safeguards, it is very interesting actually to understand those safeguards, whether they are illusory, whether just. But in any case, for the time being, as far as this judgment is concerned, it treats those safeguards are reasonable. Now, when there is a correlation and these justifications were rejected, I mean, the grounds were rejected by bringing about a purposive interpretation. In view of the grounds raised of the CRPC, because CRPC is a different law, PMLA is a different law, CRPC prescribes a different procedure, different deprivation under Article 21. That's a different test under Article 21. Now, as far as the PMLA is concerned, there is a different test under the Article 21, so far as this entire law is concerned. The line of attack, bringing the CRPC principles and provisions, being the sacrosanct of 21, that thus far Article 21 can go and no beyond, is rejected by the court by saying it's a special legislation. Now, let me tell you, we need to understand, apart from this the design which I told you and this particular legislation. Another important aspect, the scheduled offence, which is the predicate offence, through amendment to the statutes to the scheduled offence, the central government is keep on adding to it. So in other words, remember, as you know, our every inch and millimeter in many sector, we are already captured by multiple legislation. For example, in banking sector, in mining sector, in power sector, sector-wise sector, you will see that there are multiple legislations operating at the same time. There are multiple regulators that are operating at the same time. And as I told you, with the reasons to believe, the three word, a phrase which the entire statute can be triggered, and to the extent saying that, okay, there is a safeguard that if a vexatious search is carried out under section 62, the virus also was rejected, that section 2 virus challenge was rejected also. There also, another interesting aspect has lost sight of the Honorable Court, that when a authority triggers these proceedings, arrest without recording reasons, that without recording the reasons is the only parameter. If a authority triggers the PMLA, whether it's the attachment proceeding or the prosecution, without the recording of the reasons, and takes any action under the statute, then in that event, it will fall under section 62, and then only there can be a prosecution of that officer. But mind you, this section 62 is only applicable only in the extent of the written reason is not given there. In any case, assessment that there is a reason to believe, and I have reasons to believe, that assessment is not questionable. So only the absence of a recording, one can be prosecuted. So therefore, in any case, if somebody has to prosecute you, he will only record a reason and he will prosecute you. So in other words, the important aspect here I wanted to draw to your kind attention, to all of your viewers, with all these elements and all these solitary elements of reverse burden, presumption of innocence, reasons to believe as a concept to trigger a prosecution, inquiry, Article 23 not applicable in this case because they are not accused, and then incriminate them, threaten them and incriminate and get all this evidence, and then you make them accused. All these principles, remember, are separately adjudicated under different statutes. And those judgments were cited to uphold this particular legislation, which is a combination of all those devious jurisprudential principles. And I'm giving a small example. I think we are done. Almost, we are reaching to the end. Note, I'm giving an example. I am dealing with some of the matters, and I know that a mining sector, one wrong judgment came. A mining sector, one wrong judgment has come. That a action was treated to be illegal at a subsequent time. That particular action has been prosecuted by 14 agencies under 10 different laws. And that action of 20 odd years, even today also now being prosecuted under the money laundering law. It's like this. Carrying out a mining operation, they carried out as per their supervision, control, and regulation, and all administrator, all regulator at appropriate time, 2000 to 2010. There was an allegation that while undertaking mining operation, environmental clearance was violated. And believe me, not even one operator in entire India were found to be incompliant of that interpretation made subsequently. Not even one operator. An action which was then legal interpreted later on to be illegal. And pursuant to that, 15 agencies, 10 operators, 10 statutes prosecuted for the same actions. And now that is also falling under the prosecution of the money laundering, and there are prosecution have begun. What a message I wanted to convey. Gone are those days where we used to sit back and say that a judgment is coming. All right, that consequences will also visit me. And let us see that. India is a 1.4 billion population with a so little judicial infrastructure. And the complex laws like the money laundering being thrown at us, where I saw there are 3 prosecutions separate happening under the one single legislation, one action, under one predicate and 2 PMLA. What are we trying to achieve? And as I told you, the jurisprudential concepts and the principles developed at a separate law under different legislations are being cited in this law containing 6 devious elements. It is, I always call it, this is a law, it transcends the entire 8 billion population is under the thumbnail. It's just that whether the infrastructure allows them or not. Every transaction is a potential money laundering, proceeds of the crime. They have to investigate, they have to inquire, they have to find out whether this particular one is or not, or it is there or not. And believe me, the time has come to address these issues with a more robust way. Make it minimalistic, because with a lesser judicial infrastructure and mounting jurisprudential concepts like PMLA and all, which is busy, which is making busy all the courts throughout India. Today, if you go to any courts, you will see, look at the amount of the number of cases and it's so complex law. We are eating out the valuable judicial time. With the economy growing up, there are new people, new litigants are coming. They are needing also the redressal. What are we doing? Therefore, it is a responsibility of us, me, you, each one of us, to make this subject a little simpler. I think I can only invite you that in the meantime, I have broken up this particular law into different, diagrammatic way, which I am using it in the court for a simplistic utility, to making it absolutely clear with a clarity, to make the judges also feel confident in granting an order, make it a very, very simplistic way. You can collect those contents for your applications, because this is not a law which is only applicable to my clients. It is also equally applicable to me. So forget about that the litigation is becoming a reactive concept. Today, the time has come that whenever there is a problem happening, or whenever there is a substantial proposition of law is getting declared in some courts or somewhere, a substantial, collective, crisp effect and efforts need to be done. Hopefully, I try to cover, but I generally prefer to have an interactive session. But surely the time this is such a complex subject, and this subject does definitely, each of the judgments ratio that the Honorable Court has stated can take about 30 odd minutes to understand the entire gamut. And I was given only 1 hour time. I think I have already exceeded the time, but I invite all your suggestions. I am always looking into applying the law in a very constructive way. Hopefully, I made my presentation easier for all to understand, including those who are not from the legal fraternity. Thank you so much for sparing this time, and looking forward to seeing you again. And thank you once again, Taxmann, and to all of your the colleagues and people who tirelessly work to bring this particular webinar to the people, to your viewers. Thank you so much. Thank you.